Hello, welcome back. So what we are going to look at today is the evaluation for occupiers liability. Now, I've done this all as one, so I've kind of put both acts of Parliament in here. So the first point is that the law comes from statutes. So this means it's made by Parliament. I would make the comment that this is democratic. Parliament is sovereign. They are the law-making body in this country. You could also comment on the fact that the two acts are now between 40 and 60 years old, a little bit more than that, I think, the 57 one, and maybe they could do with being updated. However, if they are working well in practice, which they seem to be, as long as it's not causing any injustice, that's what we really care about in law, is injustice. So if they are working in practice, then it's fine. Okay, the second point I put is the acts lack definition. So there's no statutory definition of premises or occupiers, and therefore it's left up to judges to interpret and define these key terms, which is okay because judges are legal experts. However, they're not elected, so it is undemocratic. The next point I talked about was there are issues with civil courts when bringing a claim. So this is a kind of generic point about the civil system. There are long delays, it's very expensive, damages as well that judges award can vary from case to case. It's very difficult for you to fund a personal injury case. You're not going to get any legal aid, so you're going to have to use a no win, no fee company, and they will take a large percentage of your winnings. Okay, the next point I put is that a visitor must be kept reasonably safe. Now, whenever that word in law is used, there's an issue of, well, what does that mean, reasonably safe? I mean, the courts have said, well, reasonably safe. So it's quite vague, it's open to interpretation. The law is saying you don't have to keep somebody completely safe, so that works in favour of the defendant. And I think the law is requiring visitors, whether they are lawful or unlawful, to actually take some responsibility for their actions. The next point you can talk about is children. Well, children have greater protection if they are lawful visitors. So I've written that, this is logical, as children have less idea of a risk. The way their brains work, they don't perceive risks as you or I do. So the law ensures that parents are going to take some responsibility for their children. So when you look at the case of Pips, the two young children, 5 and 7, the council were not liable because the parents have to take some responsibility. So that's a good thing for the defendant. I've also put that people are protected because the defendant cannot exclude death or serious injury from the negligence. So you've got to take higher standards of care if you are an occupier. Defendant is protected in many ways because tradespeople, if they know of risks, then the defendant will not be liable. So think of your carbon monoxide case with the chimney sweeps. The other thing that's worth discussing is the fact that the defendant has some defences available to them. So contributory negligence, warnings and consent. So warning signs, if they are obvious and clear, then the defendant will not be liable. So there's a lot of protection offered to a defendant under these acts. However, what amounts to an effective warning? Will a child understand that warning? Will a person of low IQ understand that warning? And again, the defendant has no liability if the danger is obvious. Well, that raises the question of what is an obvious danger? Obvious to who? Obvious to the reasonable man, so Lord Denning's man on the Clapham omnibus, or obvious to the claimant themselves. The other issue that's worth discussing is, should the law protect trespassers at all? It seems unfair on an occupier to have to be responsible for a trespasser. Trespassers are not meant to be on their property, so why should an occupier be responsible for an injury? I mean, it's your house, it's your property. So I mean, the law didn't protect trespassers until the 1972 case of Harrington, and then Parliament clearly thought, well, actually, we should protect trespassers. So it's definitely a discussion point. However, what you will have noticed in the AO1 video, that when we're talking about the cases, there are hardly any, well, I don't think there are any cases that we looked at where the claimant was successful. So if you are a trespasser, your chances of being successful in a civil claim are very, very low. So maybe that's the courts hinting that they're not happy with the fact that an occupier should be responsible for a trespasser. So in terms of reform, no current proposals, but if you wanted to suggest something, you could say, why don't we consolidate? Why don't we put those two acts in one place? I don't like it when we have different bits of law everywhere. It's confusing for the layperson. And maybe something like you could get people to take out compulsory personal injury insurance. I mean, I'm not sure that would work, but it's a suggestion. Okay, so lots of points, and I'm sure you will think of many, many more. That's just an overview of some of the key points, but have a think, and if you've got any questions, always put them in the comment box. And as I said in my earlier video, if you want me to email you anything, please feel free just to ask. Okay, so thank you very much. See you soon.